a legal mind through our moderator. And I trust that in the end, we'll all leave here informed and committed to making some changes where necessary. So I want to thank you all for being here. If you look under the participants and you're seeing someone who should be here and is not here, then you know that you need to make a phone call. God bless you, and we're looking forward to a good evening. Thank you, Madam Secretary.
Thank you. Thank you for the greetings, Madam President. And I do hope that as you journey in your wherever you're being taken this evening and otherwise that you will be safe and you will
Thank
be
you.
well. Get
Thank
to
you
your
so
destiny.
much. When you said that our presenter was on his way from Hanover, I said, boy, we are trading places
Swapping.
because I'm on my way to a function out west as well. So we may pass each other on the highway, but safe travels to you as well. Or to, I know you said your son, but to Mr.
Yes.
Young, safe travels as well. We're crossing paths.
Okay. Thank you, Madam President. And I also want to acknowledge the other members of the executive who are on this important call this evening. I know I had made mention of our vice presidents, but I do see other executive members online, and I want to acknowledge them and thank them for their support and for their participation, as well as their prayers as we go about the work of the Jamaica Baptist Women's Federation. I would like now not to detain us with formalities and to get right into the presentation with Mr. Young, but I have it's not dubious, but I would say a great honor and a privilege to introduce my friend who I consider my son. I consider a friend, and we journeyed together during the last stretch of our law school endeavor, and sometimes we must speak the prophetic. I don't make any claim as to being a prophet, but this young man, I suspect, will be one of the first to be admitted to the inner bar when the time comes from our cohort because of his genius. He has been working at the CPFSA even before leaving law school, and he has been doing very creditable work in developing our jurisprudence here. So he is one to watch. He has taken on some giants and taken them down. And he's quietly making a reputation for himself, advocating for the rights of children and of parents as well. So Mr. Charles Young is an alumnus of Campion College, and he went directly from Campion to the Faculty of Law at the University of the West Indies. He was successful in completing his preliminary studies in the law and matriculated for the Norman Manley Law School in 2019, and he finished on time. He has done well for himself. He also prides himself on being somewhat of an athlete. That remains to be developed and seen, but we pray him up. Charles is he's a delight to work with, and I have nothing but good things to say about this young man of much promise. During his time at the law school, he was involved in leadership. He actually spearheaded the largest charitable campaign undertaken by students by chairing what was the name of the committee again, Charles?
The Children's Outreach Program.
Yes, the Children's Outreach Program, where we did some remediation work at the Sir John Golding Rehabilitation Center. We did a treat, and it was a huge day that, so we refurbished bathrooms, refurbished, I believe, the kitchen, and we made some contributions to the home. And I believe that they are still remembering that labor of love that was done in the midst of a pandemic to be probably the most successful undertaking of a partnership with the Sir John Golding Rehabilitation Center. So I will now yield to our keynote speaker this evening. If he has a presentation, Charles, go ahead. You do have presentation rights, and we look forward to what you are going to be sharing with us this evening. So thank you for accepting the invitation, and we look forward to a rich time of fellowship with you.
Okay, good. Sorry, good afternoon, good evening, everyone. Thankfully, I've made it from Hanover, so I'm able to make this presentation. I must say, however, that I didn't expect such a glowing introduction. I almost can't stop smiling. I feel almost as though I'm not the person being introduced. I don't know that I can live up to everything that you've said, but certainly I will try my best to. But thanks again for having me. So thanks again for having me here today. Truly, I really appreciate it. And while I presume that this is a group that is generally constituted to celebrate the glory of God and the reverence associated with his mercies, I'm grateful that you found it suitable to discuss this topic, and even more that you deemed me the person suitable to discuss this topic with you. So thanks again. As it relates to the legal framework in Jamaica that protects the rights of children, it is primarily governed by the Child Care and Protection Act. There are, however, bodies of legislation that protect the rights of there are, however, other bodies of legislation that protect the rights of children. These include, but are not limited to, the Child Pornography and Prevention Act, the Sexual Offences Act, the Offences Against the Person Act, and the Child Diversion Act of 2018. So I like to think of children as citizens that receive double protection. And I say that because children receive protection by rights by way of their capacity as a citizen of the country, but they also receive further protection by way of the fact that they are children. So for every law that regulates a citizen in the country, it is also relevant to children. But then you also have a set of legislation that is only applicable to children and protect their interests. So starting with the Child Care and Protection Act, this legislation forms the cornerstone of child protection in Jamaica. And by this, I mean that this is the most substantive body of law or legislation in the country that regulates the rights of children and how are they to be treated when they come before the law, or in anything that is related to the legal framework and children, legal framework in the country and children. So the CCPA, which I might use throughout this presentation, is the short form for the Child Care and Protection Act. And the CCPA was enacted in 2004. It outlines the rights and safeguards that every child in Jamaica deserves or is entitled. And this act covers a wide range of areas, including child cruelty prevention, mandatory reporting, care and protection, intervention, criminal liability, and child employment. One of the key aspects of this act is the definition of child cruelty, which encompasses various forms of physical, emotional, and sexual abuse, as well as neglect. Now, it's interesting because when we think of child abuse, another thing is in the act, as much as we say child abuse, what's interesting is from a legal perspective, child abuse isn't used in our laws. What is used, however, is child cruelty. So from a legal perspective, as much as child abuse tends to be a more layman term, in the legal context, what's typically used is child cruelty, because that's the phrase that is used generally in our law. And what I wanted to point out, however, is neglect, and that's because we like to think of, whenever we think of child abuse or child neglect, we often think of actions, active actions that lead to some form of abuse or cruelty in relation to the child. But what the law provides for, however, is neglect. So the omission to do things can also constitute child abuse or child cruelty, which is something that people often forget or fail to consider or might not necessarily be aware of. So as I mentioned, what is interesting is that although we often speak of child abuse, there is no offense for child abuse or definition for child abuse under the CCPA, the Child Care and Protection Act. Rather, it provides a clear outline of what constitutes child cruelty, and it aims to ensure that every child's physical, emotional, and psychological well-being is safeguarded. Child cruelty is an offense, and it is defined under Section 9 of the CCPA as being an adult and having the custody charge or care of any child, and willfully assaulting, physically or mentally ill-treating, neglecting, abandoning, or exposing such child, or causes or procures a child to be assaulted, physically or mentally ill-treated, neglected, abandoned, or exposed in a manner likely to cause that child suffering or injury to health, including injury to or loss of sight or hearing or limb or organ of the body or any mental derangement. So as I rightfully pointed out earlier in my presentation, child cruelty contemplates active forms of cruelty, meaning doing acts that will physically impact the child, but it also contemplates neglect, and that is failing to take care of your children or prevent them from being exposed to danger. And what was also mentioned, which I failed to discuss earlier, was that child cruelty also contemplates not just the physical, but the mental aspect of a child's well-being. So it is possible to be charged for the offense of child cruelty if it can be shown where your actions or lack of action led to a mental derangement or adverse mental impact on the child. So in addition to what I just discussed, the CCPA establishes mechanisms for reporting suspected child abuse. It encourages anyone who suspects or becomes aware of abuse to report it to the appropriate authority being the Child Protection and Family Services Agency. And as it relates to child abuse as well, I explained that the term child abuse, even though we all know what it means, isn't generally represented in legislation. And another term that is used that is similar to child abuse is children in need of care and protection, or a child who is in need of care and protection. So in circumstances where you would say a child who has been abused, uh, instead of from a legal perspective, what would typically be said is that it's a child who is in need of care and protection. And the average person everyone has a duty to report when they suspect that a child is in need of care and protection. A child, and as and I'll every person has a duty to report when they believe that a child is in need of care and protection. That is, they suspect that the child has been abused or is being abused or is likely to be abused. Now, in the Act, what's interesting is it outlines a prescribed person. So one of the things about the CCPA that it is hailed for, or has been hailed for since its inception, is mandatory reporting. And I'm not sure if you've ever heard of that term before. A mandatory reporting simply means that when any individual is aware of a child that has been abused, or is in need of care and protection, they have a duty to report that child, to report that incident to the CCPA. Not the CCPA, sorry, the Child Protection and Family Services Agency, the CPFSA. The Act mentions prescribed persons and every other person, right? Based on the wording of the Act, every person has a duty to report suspected child abuse. As a layman term, or a child in need of care and protection. There is, however, an emphasis on the prescribed person. So the Act outlines who a prescribed person is: a doctor, a teacher, a guidance counselor, anyone who by virtue of their duty would have close proximity to a child or would have care and protection of a child. Right? And so the Act clearly outlines that any prescribed person who fails to make a report, it can be charged with an offense if they become aware of it. The fact that a child is in need of care protection, they have a duty to report. They have a duty to report. But the Act also goes on to say that every other person, so every person besides a prescribed person also has a duty to report, and failure to report is also an offense. The thing, however, even though from a legal perspective, mandatory reporting is applicable to all citizens in the country, in my view or in my experience, there's a greater focus on the prescribed person. So the person who has a duty to take care of children or is in close proximity to children. And I think the general objective, or I wouldn't say objective, but I think the general intention behind the focus on the prescribed person is because these are persons that ought to, above everyone else, consider the best interest of the child, upon which the CCPA and all legislation relating to children contemplates. And so if anyone should have made a report in those circumstances, it should be the prescribed person. So there's generally a greater focus or emphasis on the prescribed person. But nonetheless, every citizen in Jamaica has a duty to report when they suspect that a child has been exposed to child abuse, or when they suspect that a child is in need of care and protection. And as it relates to every person having that duty, it's outlined in Section 6.2 of the CCPA, the Child Care and Protection Act. So Section 6.2 of the Act states that any person who has information which causes that person to suspect that a child has been, is being, or is likely to be abandoned, neglected, or physically or sexually ill-treated, or is otherwise in need of care and protection, shall make a report to the registry. And Section 6 further goes on to outline that it is an offense not to make a report. All right. So reporting as a general concept or practice is crucial because it enables early intervention and ensures that vulnerable children receive the protection and support they need. Also keep in mind that the Act says that when you have information that leads you to suspect that a child has been, is being, or is likely to be ill-treated, neglected, or abandoned, they have a duty to make a report to the agency, which I just outlined a while ago. Let's briefly, having the CCPA also outlines a number of other. Sorry. um, outlines a number of other things in relation to children. It outlines that children, so much as possible, should not be placed in adult correctional facilities. They should not be placed in the same area as adults. They, offenses, when they're charged with an offense, it should be brought at children's court unless they're charged with an adult, at which case it's brought to the parish court. It outlines criminal responsibility, that being the age of 12. It outlines that, the police must notify the Child Protection and Family Services Agency when a child has been in a lockup for um uh an undue amount of time. It allows for children's officers to bring children before the court if they're deemed to be in need of care and protection so that they can receive help from the state. It outlines that intoxicating liquors should not be sold to children. It outlines that children should not be working in nightclubs. It outlines that it outlines a number of things in relation to the welfare of children. Now, the CCPA, the Child Care and Protection Act aside, let's briefly touch upon some of the other legislation that work hand in hand with the Child Care and Protection Act. So the Child Pornography Prevention Act specifically targets the heinous crime of child pornography, aiming to prevent the exploitation of children for sexual purposes. And this act reinforces Jamaica's commitment to combating child exploitation in all its forms. The Sexual Offences Act addresses various offenses related to sexual abuse and exploitation, including rape, incest, and unlawful sexual intercourse, and assault. It ensures that individuals who commit such crimes against children face appropriate legal consequences, providing justice for the victims. Examples of these offenses are sexual grooming of a child and sexual intercourse with a person under 16, which are sections 9 and section 10 of the Sexual Offences Act, respectively. You have the Offenses Against the Person Act, which also plays a significant role in protecting children by criminalizing acts of violence and harm. This act takes into account offenses that cause bodily harm or endanger the lives of children, ensuring that those responsible are held accountable. Lastly, I would say one of the most important, I think, most recent legislation that has had one of the greatest impact on children is the Child Diversion Act, which emphasizes the importance of diversion programs for children who come into conflict with the law. It focuses on rehabilitation and the reintegration of children rather than punitive measures. All right, it recognizes that many children need guidance and support to lead productive lives. In this act, it also outlines a list of offenses in the first schedule, and any child who commits one of these offenses can be referred to participate in a diversion program once certain conditions are met. These conditions include, but are not limited to, the consent of the victim, the consent of the child, and an acceptance of the wrongdoing by the child offender. This act is very important because most of the children are not beyond reform, and correctional facilities are not always the best solution for these children. And so the Child Diversion Act merely acknowledges that a child is, as a human, is still in the embryonic stages of their development, and therefore, and I think a lot of us can remember when we were children, and as mature as we thought we were at the time, or decision making, or capacity to make reasoned, sound, and morally accurate decisions wouldn't have been at the same level as they are now at our stage of our life. And as children, sometimes we don't have a proper appreciation of the consequences or the actions or the true implications of our decisions. And not only that, but who you are even despite your decisions as a child, you still have the capacity to change later on in life. And not just that, but it's important to give children a second chance and an ability to rehabilitate, and to be, productive members of of the society. And the Child Diversion Act simply acknowledges that by giving children an opportunity to address maybe what might be the core reasons for what led to the offense for which they were charged. The offense for which they were charged. And as I rightfully said, generally, in relation to a child's participation on the child diversion program, they would have to accept responsibility for what they've done. The victim would have to, or the alleged victim would, if can be found or located, would have to consent to the child's participation in the program, though the court can dispense with the consent, but generally it will not. And I mean, and I think even that, when I try to explain to, I always explain to my clients whenever, for instance, I try to pursue child diversion, and it's the fact that, your right as a child to rehabilitation still has to be balanced against another person's right to justice. And so, when you are charged for an offense, it's usually because you committed an offense against a person or the state, as the case may be. And the reason why you have these, criminal or court proceedings is because justice has to be brought. And when you have been wronged, when you have been wronged as a person, you have been wronged. You have the right to also want for justice to be conducted in the manner that has been prescribed by our laws. And so irrespective of whether the defendant or the person who committed the offense is a child, you have the right as an individual to want justice, or for things to take the natural course of action. And so if somebody says no, they don't want to pursue child diversion, that is their right. That is their right. If the court is of the view, however, that the consent is being unreasonably withheld, then the court can dispense with consent. Generally, that's not something that happens because
4923.
everybody has the right to justice. Just as a child has a right to rehabilitation, but that still has to be balanced against the individual's right to justice. And so if they don't want the child, they want to pursue criminal proceedings or for it to run its natural course, then they have that right. And then the child generally would not participate in child diversion, and it would just have to go to trial. So that's something to consider. The child has to accept responsibility. The victim has to consent if the victim can be located, and child has to accept responsibility, and the acceptance of responsibility has to be done in front of a parent or the attorney. And that is important because what the law contemplates is that it doesn't want children to be coerced into a decision, and by, for instance, a constable or someone from the Jamaica Constabulary Force. They want the child to be adequately advised by a relevant guardian or parent or counsel, legal advisor, as the case may be. And so acceptance has to be in the presence or would have to be in the presence of a parent, somebody appointed by the parent, or the person's legal representative after having had everything explained to the child. So that's generally what happens with the child diversion. That's generally what happens with the child diversion program. And I think it's one of the best legislation that has been recently promulgated in relation to children, because all programs are tailored to the specific child, and also all programs are tailored specific to the child, and there has to be a report. Reports are quarterly, so participation in the program is generally over the period of a year, and their quarterly reports, unless the court has requested reports to be done on a more frequent basis. And one of the things I failed to mention with a child diversion program is that a child can successfully participate in it or unsuccessfully participate in the program. So if a child is unsuccessfully participating in the program, or they haven't been progressing in a suitable or manner, in the manner that is desired, then the court has to ask itself or of the child diversion officer who has conduct of the child or the matter as to why the child hasn't been successfully participating in the program, whether it is as a fault of the child or whether it is as a fault of the program. If it's a program that is failing the child, then the court will ask for the program to be reassessed and for it to be reconstituted so that it can be more applicable or more beneficial to the child. If it is that it's the child's behavior or attitude or conduct that has generally led to the failure of the program, then the child will have to face the substantive charges. And if a child commits an offense within 3 years of a child diversion, of having been on the child diversion program, then they won't be able to rely on the program that time. They will have to face the charges. So those are a number of things in relation to the child diversion program. And I think those are the main things in relation to legislation that I wanted to address you all on today. What I will say, however, is that as a church community, or responsibility to protect children and nurture our children is paramount. It is something that is very important. And we can play a vital role in creating a safe and supportive environment where children can thrive and grow in their faith. By raising awareness about these legal frameworks or legislation, we can also ensure that every child's God-given rights are respected and upheld. So in conclusion, what I will say is that the Child Care and Protection Act, along with the supporting legislations, stand as a shield against child abuse and neglect, or as as is used in our legislation, child cruelty. And it can be used again as a shield against child cruelty or against placing them in a position where they can be considered to be in need of care and protection. Let us remember that as you gather to celebrate the glory of God, we are also called to protect the most vulnerable among us, our children, and by upholding these laws and advocating for their effective implementation, we can truly make a difference in the lives of the young souls that are entrusted in our care. Before I go, though, I'll share a scripture, Ephesians 6 verses 1-4, which state that children, obey your parents in the Lord, for this is right. Honor thy father and mother, which is the first commandment with promise, that it may be well with thee and thou mayest live long on earth. And ye fathers, provoke not your children to wrath, but bring them up in nurture and admonition of the Lord. And I share this message because it is a message that is very powerful. What it says to us is that, yes, children must be obedient and follow the instructions of their parents. It says that, yes, children must be obedient and follow the instructions of their parents. But what it also says is that parents have a duty to raise children in such a manner that they are surrounded by love and nature and not resentment. And so we have children have a duty to obey their parents, but parents also have a duty to foster an environment where children can foster and grow and properly develop, both physically and mentally. And I think that is what I'll leave you with for today. So in that absence, In the absence of anything more to say, I think that is the extent of my presentation. I will yield to the moderator uh, so that she can take over and canvass any questions from this wonderful group of women. And if you do have any questions, I will try my best to answer them. Thank you.
Thank you so much, Charles. This has been a lot to kind of take in and to contemplate, especially as we are charged or tasked with ensuring that we protect the vulnerable of society. Just to recap very quickly, I'm going to ask us to mute our microphones if we can. And you can unmute. Just raise your hand if you have a question, and you will be acknowledged, and then you will be invited to ask your question. But just some quick salient points from what Charles just went through. I realize that no, the language of the law speaks to child cruelty versus abuse. So we bandy about child abuse a lot. But if an offense is to be prosecuted, it is child cruelty, right, Charles?
Yes, that is correct. That is correct.
And so there is a physical and there's an emotional component of that. And I'm sure that is something we're going to have to take a long, hard look at if we want to re-educate society. And we are on the hook. Whether we do something or we don't do something, we can be found wanting by the law. And even though the law speaks to certain prescribed professions, we are, as ordinary citizens, have an obligation under the law to ensure that if we know of any acts of cruelty against children, that we make the necessary reports. But I want to, and I don't know if persons will agree with me on this, but I think there is some scriptural reference that speaks to sparing the rod and spoiling the child. So I grew up in an age where corporal punishment was a thing. And I think the act as it is now would contemplate that corporal punishment is considered abuse. Well, some forms of it, and if it's extreme, it would be considered abuse.
Well, the act as it is now only contemplates that corporal punishment is illegal in residential childcare facilities. So if a child is in a residential childcare facility and they're subjected to corporal punishment, then that is illegal. But outside of that environment, strictly speaking, it is not illegal. I know there's a general policy. There's a general political policy not to mete out corporal punishment in schools, and it is advised in the home environment to find other alternatives to corporal punishment, but it is not illegal in homes or schools unless the school is in a residential childcare facility. In that instance, then it is definitely illegal. When you did mention extremes, though, and if corporal punishment, as a result of the corporal punishment that is meted out to a child, it can be considered child cruelty, then yes, it would be illegal. But it's not that the corporal punishment would be illegal. It would just be that your punishment would have reached the standard would have reached the standard of child cruelty. So where there is, for instance, burns, severe breakage of the skin, loss of a form of appendage, or or something to that extent, then yes. But where there's no breakage of the skin, no severe bruises, nothing to that extent, then it wouldn't be illegal. From a legal standpoint, it wouldn't be illegal to mete out corporal punishment in, the confines of you.
Want to hear that clearly? Okay, I thank you for that clarification.
No problem.
I don't see any questions in the chat. Is there any question from the floor? Sister McLennan, go ahead.
Thank you. Mr. Young, I would like you, sir, to further. Thank you for your presentation. Very enlightening. But I would like you to further tell us on the platform the fines if we know of an abuse or other forms of thing happening to a child and we don't report. What's the fine for that? Because if we have a duty to report, and if we don't, what will happen?
Okay, no problem. So this is so if you ever get the chance, Section 6 of the Child Care and Protection Act speaks entirely to mandatory reporting. That is, who has we all have a duty. It outlines who a prescribed person is, and it does outline the offense. To answer your question, I'm just saying that for general information purposes. So if beyond this conversation, you want to look for yourself, or you're in a forum that it's being discussed, you can say Section 6 is where it talks about mandatory reporting. But Section 6.4 of the Child Care and Protection Act addresses the penalty as it relates to your failure to make a report. And Section 6.4 says that a person who contravenes subsection 2 or subsection 3 commits an offense and shall be liable upon summary conviction before a resident magistrate to a fine not exceeding $500,000, or to imprisonment to a term not exceeding 6 months, or to both such fine and imprisonment. So you can be if it's at the parish court, you can be fined up to $500,000, or to a term of imprisonment up to 6 months.
Wow.
Yes. And just for clarity, it says a person who contravenes subsection 2 or 3. Subsection 2 and 3 is where it outlines that a person has a duty to report. So subsection 2 speaks about any person who has information, and which I read for you earlier in my presentation, and subsection 3 focuses on a prescribed person. So subsection 3 says that a prescribed person who, in the discharge of that person's duties, acquires information that ought reasonably to cause that person to suspect that a child has been, is being, or is likely to be abandoned, neglected, or physically or sexually ill-treated, or is otherwise in need of care and protection, shall make a report to the registry in accordance with the provisions of this section. And then, as I read for you, subsection 4 says that if you contravene subsection 2 or subsection 3, you can be fined or imprisoned. So, yes.
Thank you. This continues to get unwieldy.
So why I wanted to stress it is because a lot of people are of the impression that only, because there's from a policy aspect of things, there's a great focus on the prescribed person. And a prescribed person, as I say, is somebody who, by virtue of their duty, by virtue of their occupation or work, has a duty to children. And so there's a great focus on the duty of a prescribed person to make a report. But the reality is the legislation also speaks to any other person or every person. So as much as there's a policy focus on the prescribed person, within the context of the law, any person or every person who has information in relation to children who have been abused or subjected to child cruelty or who are in need of care and protection every such person has a duty to make a report to the Child Care and Protection, to the Child Protection and Family Services Agency.
Thank you, Charles. Sister Marine, your hand is raised.
Yes, thank you very much, Madam Moderator. Thank you, Mr. Charles. A point I'd like to raise is on that very same matter of duty to report. I remember when I was working, I spoke to a group of persons about that very act and the possibility of having to pay that amount of fine. And they say, but miss, we don't want anybody to call us informer. And they might
Informers,
just
that's right.
know that I might be the person because I live beside them. What do I do when they turn on me? You know? So
Well,
these are
well,
some of the
go ahead, sir. These are some of the
these are some of the constraints I think that prevents a number of persons from reporting the intended abuse or the knowledge of the abuse taking place.
A question time. We soon finish.
Mhm.
yeah, we'll soon finish. Don't worry, let them know.
Yes, so what do you say?
Oh, okay.
to-
No, and that is a true, honestly, and that is a big issue that we that's a big issue that we often contend with. And sometimes you have the opposite of that. Sometimes you have people who don't care if they're informer or not, and they make the
Mhm.
report, and sometimes they want to follow up with us on where the investigations are. But the
Mhm.
thing about it is, once you make a report, it's considered confidential, so nobody from the agency should ever reveal. Uh, Nobody from the agency should ever reveal who made the report, nor should they reveal the contents of the investigation to anyone. And if someone from the agency reveals who made the report or contents of the investigation, uh, then they can be charged. It's an offense. It's an offense to reveal who made the report, as well as to reveal the contents of an investigation. And so for the people who are scared, so it's a double-edged sword, for the people who are scared about being an informer, that those provisions in the legislation protects those persons. But it also, I guess, prevents people who are genuinely interested in the welfare of the child from being provided, uh, from being given updates in relation to the report that they would have made. But I think that is the level of reprieve that is provided from the by the legislation, and the person can also take comfort in the fact that if anyone reveals that they made the report, that person can be prosecuted
Good.
by 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 the uh, by the law, and so that you can make a um bring a matter against the person who would have disclosed who made the report. I think that is something that the person can take confidence in. I think the only concern now for that person is where, based on the circumstances, based on the circumstances, uh, they're the only person who could have known that information, and so by way of deduction, it can be figured out. But they have to think about consider the cost of compliance versus the cost of non-compliance, and what
Mhm.
is what is most important.
Yes, that is
Um,
so true, sir. Because there are even some teachers who are afraid to report what children have said to them, particularly about sexual misconduct. The children report to them, they observe behaviors, and they find out what's happening. And they don't know what to do with this because when they report it to the principal or persons in authority, these parents or so might be influential and are contributing to the school, and so they're being warned.
being on, oh, okay. Well, I mean, in those circumstances, I mean, really and truly, the teacher does have a duty to report. I guess what they have to ensure that that they what I think what they have to do is ensure that when they're making the report, that that it has to be that they have to explain the circumstances. And I mean
Oh, they
the
get.
children's officers are aware of, this is not the first time things like this would have occurred. In fact, the matter that I'm coming from Hanover for is like is an exact, you know, how to say, is an exact replica of what the situation you would have just represented, in that, you know, a person would have represented certain things to their guidance counselor, who then subsequently made a report um, to the agency, and which led to the charge against a number of young men.
Yes.
And I, I don't think they know. I don't think they wouldn't have known that it was the well, actually, no. They know now that it's the guidance counselor, because the guidance counselor made a report, but because she felt strongly about it. But there are circumstances, however, where that information wouldn't have been known, and it would have just been that they received an anonymous report, or that, like the source of the information would be so unknown that it could have come from anywhere. Because the children, as I said to you, the agency has been around for a number of years now, since 2004, and these
Oh.
instances aren't novel or new, and so they know how to handle circumstances where, for instance, where the information is, where some of the parties might be of an influential background
Standing.
or standing. Yes.
Mhm.
So
Yeah.
as long as they articulate that when making the report, then the agency would know how to respond to it. I think sometimes when they don't sufficiently articulate, that is probably when when they don't sufficiently articulate, that is probably, I wouldn't say when there would be any
Backlash.
any consequence or for the person who made the report, but I think there would be greater reassurance for the person making the report when they articulate the circumstances properly, as to the parent is this type of person,
Yes.
so be
Yes.
extra cautious in how you
Yeah.
approach this matter, and how you do your investigation, because sometimes the investigations are done directly, meaning investigators will confront the person directly and say, hey, we hear this, and what you have to say. Or it might be that they discreetly, sometimes they infiltrate the community and ask questions of community members and observe. They have direct approaches and indirect approaches, and I think based on the information that's communicated, then they would know what approach to take. So we have investigators and children's officers who are well experienced in these types of matters. So long as they represent the circumstances as accurately and as relevant and as grounded as possible, then they would know how to approach the matter.
Thank you very much. I'm happy
problem.
that there are these new laws, and that the officers are now more familiar, and
Yeah.
people can now be more comfortable
Yes.
making their reports. Thank you
Yes.
very much.
No problem. And it's very important that they make these reports now, because when they
It is.
don't, it ends up they'll end up in problems. Because I'll give you an
Yes.
example as well. There's a matter involving a school where it became public of certain transgressions in relation to an employee of that school. And I think based on investigations, it would have been revealed that a number of reports were made to people by persons affected, children affected, to individuals who were considered to be prescribed persons. And those persons were almost charged with the offense of failure to report when everything became public. But what saved them is the fact that a report was in fact made, not necessarily by the individuals, but on behalf of the individuals by the institution. So the institution would have made a report based on what would have been reported by these prescribed persons. And so that's what saved them. And that was recent too. So it's very like a recent serious example where prescribed persons probably would have been charged with the offense and brought before the court because of how serious the offenses were against the children, and the concern that persons were aware and didn't make the report, but they in fact made a report and the report was found. So they were able to avoid charges. But I just said this to say, people might take it lightly and might realize like how serious it can be. So especially as a prescribed person, because as I said, the law contemplates that everyone has a duty to report, but the hand is heavier when it's a prescribed person. So
Sister
if I don't-
Marie,
yes.
Yes, Madam Chair.
go ahead.
Oh, my hand was lowered.
Okay.
Yeah. Okay. One other question. The fit person order, is it still used?
Yes, the fit person order is something that is you know a lot though.
Yes,
know a
I'm a
lot, though.
social worker. I used to work in the area.
Oh, okay, that was good. Yes, the fit person order is something that is still used to this day. So the fit person order, well, you're a social worker, so you already know a fit person order is when a child is deemed to be in need of care and protection, and the order is used to give to put the child in the care and control of someone who is deemed to be a fit custodian of the child. Generally, the fit person order is given to the state or the agency. And so that child then goes into a residential child care facility or in the care of the state. But based on even though that is typically what happens, or what invariably what always happens, based on the construction of the law, a fit person doesn't have to be the state, or the fit person doesn't have to be the agency. It could be someone else. But
Yes.
generally, the child, the fit person order is like invariably, I've never seen a fit person order being granted to someone that was not the state. So
I did. I got one.
you got one?
Yes.
Oh, look, you're the exception. I've never seen it, but I know based on the construction of the law, as I say, it's not that the fit person order has to be given to the state, but generally that's what happens. But yes, it's something that is still being done. What I will say though, and it's not something that I mentioned in my presentation, but I will mention it now, there has been a recent repeal of Section 24 of the Child Care and Protection Act. And for those of us who aren't legal practitioners, you probably won't know what section is that, but that's the section that speaks to uncontrollable children. I'm not sure how many of us might be aware, but there was a time up until this year, a couple months ago, you could bring a child before the courts as a child being in need of care and protection. They're too unruly, and they can be placed in a juvenile correctional facility. And the concern with that is that you're criminalizing children who didn't commit a criminal offense. So generally, children only end up in a juvenile correctional or remand facility when they've committed an offense, or when they've been charged for an offense and the matter has been yet to be adjudicated. But that section was repealed, and so now children cannot be placed in a correctional facility or a remand center for being
Family care support.
Yeah. What's supposed to happen is a program is supposed to be developed for that child, or that child is supposed to be placed in a residential child care facility, but they can no longer be placed in a juvenile correctional facility for just being uncontrollable, unless they're uncontrollable and committed an offense. But just for being rude or unruly, that child will no longer be placed in a correctional facility. But up until maybe August of this year, if a child was unruly, or what's the word, recalcitrant or incorrigible, I think is the word that is often used. Yes,
Oppositional defiance.
Yes, so they
yeah,
stay
yeah,
at home and kill you
Mhm.
instead.
yeah. So that's the children like that would have been placed before August, could have been placed in a residential correctional facility.
Mhm,
But
mhm.
that section of the law has now been repealed.
We'll take one more question. Charles, what's the relationship of the agency with Sissoko?
Okay, that's a good question. They're separate entities, but they have a working relationship. So when a report is made in relation to anything sexual, then
Where the key? Where the key? Your key.
then the matter is usually referred to when it's a child. Anything sexual has been reported, then the matter is usually referred to Sissoko. So the child is brought to Sissoko for a medical examination, for a statement to be taken, so that the individual, the alleged offender can be charged. Sissoko also to some extent offers counseling services. So for children in residential childcare facilities who have been subjected to a sexual offense, or were alleged to have committed a sexual offense, usually, they have individuals from Sissoko for a period of time, usually initially, to do some form of counseling with the child. But once a report involving a child has been made that's of a sexual nature, then it is referred to Sissoko immediately, so that investigations can be done and so that the child can go for an investigation. So for males, when it's buggery or grievous sexual assault, that kind of thing, it's referred to Sissoko, so an investigation can be done, a medical examination can be done. When it is a matter involving rape, sex with somebody under 16, rape, someone under 16, previous sexual assault, that kind of thing, anything sexual, male or female, the matter is referred to Sissoko for them to do an investigation and medical assessment of the child. And then that information is then referred back to the agency so that they can continue, because the agency also does to some extent investigation. Even though the investigation is that the agency does is, so the agency and Sissoko will both do investigations, but investigations that are done by the agency is more so from a social impact or social welfare aspect. And investigations that are done by the Sissoko is more so from how would I say criminal legal is more so legal and from a legal perspective, and that's from their main thing is seeing whether this is something that can be properly brought before the courts of Jamaica. And whether the person can be charged. There's someone to be charged where there's sufficient information for the person to be charged. That's the extent of like Sissoko's investigation. The agency's investigation is more so from the welfare of the child, how they were failed, who failed them, what can be done
Psychosocial.
from a mental aspect. And
Psychosocial.
yes, exactly. Like a psychosocial aspect of things. So yeah, so that's the nature of their relationship. So it's an interdependent relationship between the agency and
Thank you for that. Last call for any questions. The room has gotten quiet. So I think there is so much more to unpack from the Child Care and Protection Act, and we need to do some reflection, especially as the JBWF has responsibility for one of the places of safety based out west. So there is much to consider. We can go back and review the presentation on our JBWF Media YouTube page. And I want to thank Mr. Charles Young for a very insightful presentation this evening. And Sister Anne-Marie Patman is going to move the vote of thanks. So I'm going to invite Sister Patman at this time to do the vote of thanks, and we will follow. Sister Patman will be followed by Sister Paulette McLennan if she has any closing remarks at this time. Sister Patman.
Thank you, Madam Chair. Thank you, and a blessed evening to all. Task is mine to give the vote of thanks, and jumping straight in, I must say yet again the Education Committee, spearheaded by Sister Paulette McLennan, has scored again. Thanks to the team for this educational and informative session. Thanks to President Crossman Small, who brought greetings, VP Kimberly England for gracing us with the opening prayer, Sister Candace Walker, our moderator, and all executive members. A big thank you to our presenter for enlightening our darkness with the rights of a child. Mr. Young, we truly thank you for giving us well-needed information to guard and guide us in going forward. You reminded us that children need double protection. We also learned that child abuse can also take in the form of a child in need of care and protection. We can be charged if we are found to be responsible for children being mentally unstable. We are all responsible in looking out for our children, we are told. No doubt you are seeing through the eyes of Christ in regards to our children. Thank you, sir. Thank you. How can we not say thanks to God for blessing us with such a rich and fruitful presentation? And a big thank you to all who took the time to be with us online. We all need it to make this world a better place for our children. And always remember, train up a child in the way they should go. Thanks for reminding us, Mr. Young. And may God bless you as you continue to do what He has called you to do. Thank you, thank you, thank you.
Thank you, Sister Patman. Sister McLennan?
Yes, Sister Candice, I'm here.
I was inquiring if you had any closing remarks.
I just want to thank everyone who has contributed in any way to these forums that we have had. And just to say that the turnout tonight has been very good. Last week we were a little concerned, but tonight we want to thank those of us who put it out there to our sisters. And we want to thank Mr. Young very much for his presentation. Thank you, Sister Candice.
Thank you, Madam Chair. And all good things must come to an end. And we have been thanked, we have been informed, we have been educated, and we have so much more now to consider as agents of change and protectors and guardians of the future. I want to thank you all for your participation this evening. I must advise that there will be a leadership training exercise scheduled for Saturday morning, December 2, beginning at 10 a.m. And it will focus on managing grief and trauma. If you are so interested, please engage the Secretariat by sending us an email or a WhatsApp message at the, let me switch back so the screen can show you the address to send your inquiries to. It's jbwfsecretary@gmail.com. If you want to send a WhatsApp, the number is 383-0185. And again, thank you, Charles, for your presentation this evening. Thank you all who have joined the platform to attend. God bless you all. Have a very good evening.
You also.
Yeah, thank you. Thank you, everyone. And I hope you all have a wonderful evening.
Right.
Okay.